Good morning, class, and welcome to part 3 on my lecture series on criminal procedure. In this portion, we are going to discuss about amendment or substitution. So let me share my screen with you. Okay. Now, if you need to change or to substitute some portion of the complaint or the information filed in court, then you have to comply with the rules on amendment or substitution of complaint or information. But first, let us distinguish between amendment and substitution. An amendment of the complaint or information may involve either a formal or substantial change. On the other hand, when a party will substitute the complaint or information, it will always involve substantial change from the original charge. So when you say amendment, it can be formal or clerical change or substantial change, whereas a substitution is always and always substantial. Okay. Amendment before the plea is entered by the accused can be effected without leave of court. So before the accused enters his plea of guilty or not guilty, then the prosecution has the right to amend the complaint or information as a matter of right, even without seeking permission from leave of court. That is what we mean by leave of court. So before the accused enters his plea of guilty or not guilty, then the prosecution can amend its complaint or information even without leave of court. On the other hand, class, in case of substitution, it must always be done with leave of court since the original complaint or information will have to be withdrawn and another one will be filed in court as a replacement. Okay? Now, third, an amendment as to form will not require another preliminary investigation and retaking of the plea of the accused. On the other hand, if the complaint or information has been changed or substituted, then it will entail another preliminary investigation and the accused will have to make another plea or to enter another plea. So there will be a rearrangement. No? So in case of amendment, there is no need for another preliminary investigation. But in case of substitution of the complaint or information, then another preliminary investigation must be conducted and the accused must be arraigned once more. Okay. Now, an amended information refers to the same offense charged in the original information or to an offense which is necessarily included in the original charge. Hence, substantial amendments to the information after the plea has been taken cannot be made over the objection of the accused. For if the original would be withdrawn, the accused could invoke double jeopardy. On the other hand, class, in case of substitution, it requires or presupposes that the new information involves a different offense, which is not included in the original charge. Hence, the accused cannot claim double jeopardy. When you say double jeopardy, class, you learn this in your study on criminal law, that the accused is prosecuted twice for the same offense. Now, matters subject to amendment. As a rule, only a valid information can be amended in court. No, class. Kasi class, if the information is void, if the information is a total nullity, then you cannot amend it. Why? Because only a valid information can be amended. A void information does not exist in legal contemplation. And so therefore, there is no amendment that can be affected in a void information. Okay. An information filed before the effectivity of the law punishing the offense may not be amended after the law had come into effect. Let us go to formal amendment. What is a formal amendment? A formal amendment is made when it neither affects nor alters the nature of the offense charge. For example, class, a formal amendment on the name of the accused. Now, the name or the spelling of the name of the accused will not affect the nature of the offense charge, and therefore it can only be considered as a formal or an unsubstantial amendment of the complaint or information. A formal amendment can also take place when the charge does not deprive the accused of a fair opportunity to present his defense. Meaning to say, class, that the theory of defense will not be affected by the change in the complaint or information. And third, it does not involve a change in the basic theory of the prosecution. So those are the instances of formal amendment. Okay? The following have been held by the Supreme Court to be formal amendments or pro forma amendments. When the new allegations which relate only to the range of the penalty that the court might impose in the event of conviction, when amendment which does not change another offense, different or distinct from that charge in the original one, or when there are additional allegations which do not alter the prosecution's theory of the case as to cause surprise to the accused and affect the form of defense he has or will assume. In other words, class, the bottom line is that as long as the amendment will not create a surprise on the part of the accused in presenting or proving his innocence, then the amendment will be considered as a formal in nature. Okay? Okay. Again, when you say formal amendment, there is no need for another preliminary investigation and retaking of the plea of the accused if such were already conducted. Now, on the other hand, a substantial amendment is present when there is an amendment in substance, where it covers matter involving the recital of facts constituting the offense charge and determinative of the jurisdiction of the court. Now, class, when amendment pertains to the allegations of facts constituting the offense, ano bang ibig sabihin niyan, class? For example, if you change the allegation as to change the nature of the offense or the law violated, class, ito yung matatawag nating essential ingredients of the crime, then it is considered as substantial amendment. Or when amendment is determinative of the jurisdiction of the court, then it will be considered as a substantial amendment. For example, class, if the amendment will change the penalty imposable, no, or the nature of the offense that will change the jurisdiction from the RTC to the MTC, then it will be considered as a substantial amendment. For example, class, the crime of cyber libel, no, or libel as defined by Article 352 of the Revised Penal Code in relation to Republic Act 10175 or the Cybercrime Prevention Act of the Philippines. No, if you have amended the complaint or information to change it into unjust vexation, then it will change the jurisdiction of the RTC, because unjust vexation, class, can only be filed before the municipal trial court or the first level courts. And therefore, since the amendment will bring changes as to the jurisdiction of the court, then such amendment will be considered as a substantial one. Okay. Now, procedure for amendment. Amendment can be made before plea, both in formal and substantial amendment, no, without leave of court. Okay? So when you say substantial amendment, it downgrades the nature of the offense charge or excludes any of the accused from the complaint or information. Now, when you say before plea, without leave of court, upon motion by the prosecutor and with notice to the accused, with leave of court. However, class, after the accused has entered his plea and during trial, formal amendment can only be made with leave of court and without causing prejudice to the rights of the accused. Tandaan yung distinction na yan, class. Before plea and after plea and during trial. Again, class, if amendment is made before plea, whether or not formal or substantial amendment, it can be done without leave of court. Except in case of substantial amendment, when it downgrades the nature of the offense or when it excludes any of the accused from the complaint or information, then it can only be done upon compliance by the three requirements. One, upon motion by the prosecution. Two, with notice to the accused. And third, with leave of court or permission from the court. However, if the amendment is made after the accused enters his plea and during trial, then even in case of formal amendment, it can only be made with leave of court and without causing prejudice to the right of the accused. Take note again that if amendment is caused with the information and it downgrades the nature of the offense, it can only be made with motion for leave of court and notice to the offended party. No? This is for the purpose for the protection of the interest of the offended party and to prevent possible abuse by the prosecution. Now, take note of that. Okay. Now, amendment in the information which changes the nature of the crime after arraignment. As a general rule, class, the prosecutor can no longer amend the information after arraignment as it will prejudice the substantial rights of the accused. Class, naalala niyo yung arraignment, di ba? It is the process wherein the information of or complaint is read in the presence of the accused. And then the court will ask the accused, what is your plea, guilty or not guilty? Then the accused can enter his plea. That is the process of amendment. Now, as a rule, class, the prosecutor cannot amend the information after the accused had entered its plea or his plea because it will prejudice the substantial rights of the accused. Is there an exception from the general rule? Answer, yes. When a supervening facts changes the nature of the crime charge in the information or upgrades it to a higher crime, then the prosecutor with leave of court may amend the information to allege the supervening fact and upgrade the crime charge to a higher crime brought about by such supervening fact. For a better understanding, I will give you an example. For example, class A has inflicted a stab wound against B. Okay? But because of timely medical attention or medical care, B managed to survive the attack and he was confined in the hospital. So what the policeman filed is a complaint for homicide or attempted homicide. Now, during the course of the trial, because of the adverse condition of the stab wound, B, the victim, dies. Now, the death of the victim pending trial is a supervening fact from the time that the complaint has been filed in court. Now, because of the death of the accused after the complaint or information is filed in court, that supervening fact will change the nature of the offense. It will upgrade the crime charge and the penalty imposable. And therefore, because of the supervening fact, the prosecution with leave of court may amend the information. No? Okay. Period when substitution is proper. If it appears any time before judgment that a mistake has been made in charging the proper offense, the court shall dismiss the original complaint or information upon the filing of a new one charging the proper offense, provided the accused shall not be placed in double jeopardy. Class, substitution is done during trial. For example, you are proving the case for a complaint for a homicide. And then during the course of a trial, the evidence would lead to another offense, no, which is more proper. Then the court will allow substitution of the original complaint upon the filing of a new one depending upon the facts established in court. Okay. Now, what are the limitations on substitution of complaint or information? These are the instances, class, when substitution is not proper. Number one, when no judgment has yet been rendered. Number two, when the accused cannot be convicted of the offense charge or of any of the offense necessarily included therein. And number three, when the accused is placed on double jeopardy. Okay. Let us go to another topic, venue on criminal actions. Okay. I have discussed this during the first topic class or the first part. No, subject to existing laws, criminal action shall be instituted and tried in the court of the municipality or territory where the offense was committed or any of its essential ingredients thereof had occurred. That is section 15 of Rule 110. So class, venue in criminal cases is jurisdictional. What do you mean by that? That means that the complaint or information can only be filed in the court where the offense was committed or any of the essential ingredients occurred. Now, there are exceptions from the general rule. Number one, an offense was committed on a railroad train, in an aircraft, or in any other public or private vehicle in the course of a trip. Now, in case class that there is robbery, for example, in a railroad train, then you can file the complaint in any of the places where the train passed, no? Or the route of the railroad train. Okay. Number two, where the offense is committed on board a vessel on its voyage. Three, felonies under Article 2 of the Revised Penal Code. You remember, class, Article 2? Okay, Article 2 are the extraterritorial application of the Revised Penal Code. It shall be cognizable by the proper court where the criminal action was first filed. Alala niya, class, yung Article 2? These are offenses committed abroad, but still you can file the complaint before the Philippine courts. These are the exceptions to the territoriality principle of the Revised Penal Code. No? If you will recall under Article 2, meron dyan nakalagay na when a Philippine coin has been counterfeited abroad, you can still file the complaint before the proper courts in the Philippines, even if the crime was committed abroad. Article 2 of the Revised Penal Code, if you will recall, pertains again to extraterritorial application of the Revised Penal Code. The fourth exception is a continuous or transitory crimes. And the fifth exception is piracy. No, the venue of piracy, unlike other offenses, has no territorial limits. The complaint or information can be filed anywhere. Okay. Now, number 6, in case of libel, the action may be instituted at the election of the offended party or suing party in the municipality or city where the libelous article is first printed or published, or if one of the offended party is a private individual, where said private individual actually resides at the time of the commission of the offense, or if the offended party is a public official, then you can file the complaint or information where the latters hold office at the time of the commission of the offense. Another exception class is BP 22 or the bouncing checks. In case of violation of the bouncing checks law, the criminal action shall be filed at the place where the check was dishonored or where the check was issued. And in case of a cross-check class, the place of the depository or the collecting bank. Okay. Let us go to intervention of offended party. You remember, class, under Article 100 of the Revised Penal Code, for every crime there is a corresponding civil liability, no? Article 100 of the Revised Penal Code. Now, since the commission of a crime comes with it a civil liability, then the private offended party can intervene in the prosecution of a crime. Intervention of offended party in a criminal action. Now, what is the rule? The offended party has the right to intervene in counsel or through counsel in the prosecution of the criminal action where the civil action for the recovery of civil liability is instituted in the criminal action pursuant to Rule 111. Now, class, if a criminal complaint is filed in court, the civil liability ex delicto or the civil liability arising from the crime is jointly instituted as that of the criminal action. Sa Tagalog, class, pag nagsampa ka ng kasong kriminal, yung civil liability, no? Yung, ano man Tagalog, civil liability? Yung iyong, oh my gosh, that is the hardest question I have ever answered. The civil liability arising from the crime, yung iyong, ano man Tagalog ng liability? Yung iyong pananagutang sibil, yan, sabihin lang natin ganyan. Ang iyong pananagutang sibil na nagmumula sa krimen ay kahalo na rin doon sa criminal action o sa demandang kriminal na iyong isinampa sa husgado. In other words, class, the civil liability arising from the crime is impliedly instituted with the criminal action in court, which is why the offended party can intervene in a criminal action. Now, when a criminal action is instituted in court, then the civil liability is jointly instituted. There are exceptions. Number one, from the nature of the crime and the law defining or punishing it, no civil liability arises in favor of the offended party. For example, class, the crime of sedition, rebellion, or treason. Diba you remember, class, the Oakwood Mutiny? Diba in one of a hotel in Makati? No, these are crimes without civil liability because the offense is committed against the government of the Philippines. In case of sedition or public uprising, in case of rebellion, treason, these are crimes against national security and there is no civil liability and therefore there can be no private offended party or no intervention by a private offended party. Number two, the offended party waived the right to civil indemnity. Class, you can prosecute a crime and the private offended party may opt not to collect civil damages or civil liability arising from the crime. Now, if the offended party renounces or waives the right to collect civil indemnity, then he can no longer intervene in the criminal action. Number three, if the offended party had already instituted a separate civil action, then he can no longer intervene rather in the criminal action. So we stop here, Rule 1110, and the next meeting we will continue with Rule 111, prosecution of civil actions. Thank you and goodbye.